Chapter 3, Estate's Tale. Estate's tale come next in order. In Wiscott's case it is stated as a rule that an estate tale cannot be merged, nor surrendered, nor extinguished by accession of a greater estate. But this must be understood with reference to the estate while in the tenancy of the tenant entail and descendable to the issue inheritable under the entail. Blackstone lays it down that a man may have in his own right both an estate tale and a reversion in fee, and the estate tale, though a less estate, shall not merge in the fee. For estates tale are protected and preserved from merger by the operation and construction, though not by the express words of the statute de donis. And this operation and construction arose probably upon the ground that in the common cases of merger of estates for life or years, by uniting with the inheritance, the particular tenant had the sole interest in them, and had full power at any time to defeat, destroy, or surrender them. And therefore, when such an estate united with the reversion in fee, the law considered it in the light of a virtual surrender of the inferior estate. But he observes, that in an estate tale the case was otherwise, that the tenant for a long time had no power at all over it so as to bar or destroy it, and now can only do it by a certain special mode, as by a fine or recovery and the like. It would therefore have been strangely improvident to have permitted the tenant entail, by purchasing the reversion in fee to merge his particular estate, and defeat the inheritance of his issue, and that hence it has become a maxim that a tenancy entail which cannot be surrendered, cannot also be merged. It is obvious that the statute of entails would have been of little effect if the estate tale had not been protected from merger, and in Wiscott's case above cited, it is said that if the tenant entail the remainder to his right heirs, he may grant his remainder over, or devise it, for an estate tale cannot be merged, nor surrendered, nor extinguished by accession of a greater estate. But this exemption from merger continues so long only as the privileges of the statute de donis in favor of the issue are annexed to that estate. When the issue entail are barred, and they can no longer claim to inherit the estate in that character and performam doni, the doctrine of merger is applicable. Thus, in Hussey's case, the Duke of Suffolk was seized of the advowson of Wellbourne, in the county of Lincoln, entail, with the reversion to the king, and the Duke granted the advowson to the king, his heirs and successors. And afterwards the statute of 24 Henry 8. c. 21, was passed. By that statute the estate tale was barred, and the king granted the advowson to another in fee generally, and it was held that the grant was good, for the king had only one fee conjoined and consolidated in him, and not two distinct fees. And in the commentary on this case it is said that two fee simples that may stand in several persons distinct, when they meet in one person, cannot do so, but the great and absolute fee doth swallow up the base and limited fee. So in the Queen v. Austin, the lands of a person attainted of treason and seized of an estate tale with the reversion to the Queen, were vested in the Queen by Act of Parliament, and it was held that the entail was utterly extinct and determined, and the Queen was seized of her old fee simple executed, and could not be adjudged in of a fee simple determinable on the tale, for then there would be two fee simples in the Queen, which would be absurd. On the ground of extinguishment of the estate tale by failure of issue inheritable to the estate tale, it was ruled that the Queen was seized by way of reverter, and a lease derived out of the estate tale was avoided. In Needham and Poole's case, the lease continued, because the Crown claimed under a title conferred by the estate tale. In Simmons v. Cudmore, a person who was tenant entail with the immediate reversion in fee to himself, levied a fine with proclamations, and it was held that the right of possession under the reversion was accelerated by the merger of the time of the estate tale, and it was observed, if it should be otherwise, there should be two fee simples in one and the same person, a qualified fee determinable on the death of tenant entail dying without issue, and an absolute fee out of the reversioner, which could not be, and according to Saul Keld's report, the court proceeded on the ground that two fees immediately expectant upon one another could not subsist in the same person, and that the statute of Westminster having made estates tale a kind of particular estate, they are, the protection of the statute being gone by the fine, like all other particular estates, subject to merger and extinguishment when united with the absolute fee, and where tenant entail, with remainder to himself in fee, granted an estate to commence after the death of the tenant entail, and then levied a fine to other uses. A.S. estate became merged in the fine. So in the Earl of Shelburne v. Biddulph, the principle of Simmons v. Cudmore was acted upon, both by the Court of Chancery and afterwards on appeal by the House of Lords. Lord Shelburne, who was tenant in tail, and entitled to the remainder in fee by descent, levied a fine, and it was held that the time of the estate tail was merged in the remainder in fee. The consequence was that the possession depending on the title to the remainder in fee, became chargeable with the leases, and covenants for renewal of the ancestor of the remainder man. And in Keeneston v. Clark, Thomas de la Haye, on his marriage, settled his estate on himself for life, on his wife for life, remainder to trustees to preserve contingent remainders, remainder to his first, and every other son in tail, male remainder to himself in fee. And there was issue a son. Thomas, the father, died indebted by bond. The son died afterwards without issue, but by his will had devised the estate to the defendant clerk in fee. And Lord Hardwicke, after treating the reversion in fee as chargeable with the debts by specialty, observed, indeed the son might have suffered a recovery and barred the reversion in fee, and then the father's creditors would not have come in. If he had levied a fine only, it would have barred the estate tail, but the reversion in fee would have been liable. The cited cases show how an estate tail, when it no longer retained the quality of being descendable to the issue, would merge. But it merged in those cases only in which the fee arising from the estate tail, and the fee immediately expectant on that estate met in the same person. And it is to be observed that by suffering a common recovery instead of levying a fine, the tenant in tail might have enlarged his estate tail into a fee simple, the recovery would have barred the remainder or reversion in fee, and the title under the estate tail would have continued discharged from the encumbrances affecting the reversion or remainder in fee. Great inconveniences were felt by the charges upon the reversion being let in, when the base fee, which had been acquired by the fine, merged in the reversion, and to remedy them, it was enacted by the 39th seconds of the Fines and Recoveries Act, that if a base fee, and by the term base fee, is meant that estate in fee simple into which an estate tail is converted when the entail are barred, but persons claiming estates by way of remainder or otherwise are not barred in any lands, and the remainder or reversion in fee in the same lands, should, at the time of the passing of the Act, or at any time afterwards be united in the same person, and at any time after the passing of the Act, there should be no intermediate estate between the base fee and the remainder or reversion, then the base fee should not merge, but should be ipso facto enlarged into as large an estate as the tenant in tail with the consent of the protector, if any, might have created by any disposition under this Act if such remainder or reversion had been vested in any other person. The result of this section is, that on a union of the two estates, the base fee becomes a fee simple, and the reversion with all charges thereon is consequently destroyed. The difference between enlargement and merger is, that when the base fee is enlarged, the enlarged estate is subject to any prior charges on the base fee, and not to any on the reversion. But if the base fee had merged, the charges on it would have failed, and those on the reversion would have come into force. One estate tail cannot merge in another estate tail. The same person may have several estates tail in the same lands at the same time. For example, an estate to him and the heirs male of his body, or any other special entail, with a remainder or reversion entail, and yet both estates may remain separate and distinct. Thus the larger estate tail will not absorb or merge the smaller estate tail. Could merger operate, the line of succession under the estate entail male would be altered, and it would seem that if the estate's tail were of equal value, the one in reversion to the other, merger would not take place. A man may also have an estate entail general, and the reversion may be granted to him for an estate entail male, which is an inferior estate, for the grant of the reversion will give him a benefit. It will pass the services during the estate entail male, and thus there may be two distinct estates in the same person, giving the land in one line of succession and the services in a different line of succession, so that the services will be suspended when the same person is tenant entail under each of the gifts, and be revived when the heir in general entail and the heir under the gift entail male are different persons. But where one person has an estate tail, and another person has the remainder in fee, and the remainder man makes a gift entail out of the remainder, and the second gift entail does not embrace a larger class of heirs than the original entail, the gift will be nugatory, and for that reason inoperative and void, though the gift would have been good if made by a person who had a reversion as distinguished from a remainder, or had been made even by a person who had a remainder for an estate in general tail, or entail female, or the like, when the former gift was entail male, or in any special form which did not embrace all the heirs designated to take under the second gift. Thus, in Badger v. Lloyd, upon a special verdict the case was thus: John Lloyd, Sr., seized of the lands in question in fee, conveyed them by lease and release to the use of himself for 99 years, if he should so long live, remainder to John his son for 99 years, if he should so long live, remainder to Elizabeth, wife of John the son for her life, remainder to trustees and their heirs during the lives of the two Johns, for preserving the contingent remainders, remainder to the first, and sons of John the younger entail male, remainder to John the elder entail male, remainder to John the elder in fee. John the elder had issue, John the younger, Thomas, Paul, and Peter. John the elder made his will, and reciting the settlement aforesaid, devised the said lands in question, after the death of John the younger without issue male to Thomas, and after the death of Thomas without issue male to Paul, and if Paul should die without issue male, and none of his brothers living, then to Peter and his heirs forever. And in the will there are these words, viz. Lastly, my will and meaning is that all my estates in lands whatsoever shall come and descend unto my name and posterity, as is before specified, and not to strangers. And whichsoever of my sons shall survive and live longer than all the rest of his brothers, then he to possess and enjoy all my estates to him and his heirs forever. Yet if it shall so happen, as I trust in God it will not, that none of my sons shall have issue male, but daughters, then I will that their daughters shall inherit my estate among them. John the elder died. John the younger suffered a common recovery to the use of himself for life, remainder to his wife for life, remainder to the heirs male of their two bodies, remainder to the use of the will of John the elder, and the judgment applicable to this point is in these terms: objection that the estate tail in John the elder will destroy this devise, as, if A was tenant for life, remainder to B, his son entail male, remainder to A, and the heirs male of his body, remainder to A. In fee, A has issue another son C, and devises his remainder after the death of B, without issue to C, his second son entail male. It was objected that this devise could never take effect, and therefore that it was ill, because the estate tail in the father will descend in the same order and interpose between the estate devised by the will, and the devisees respectively will take the old entail by descent, which will exclude the new estates limited by the will, and the devise of a remainder which can never take effect in possession is void. So here, because the tail devised by their will cannot by any possibility take effect in any of the sons, because they ought to take by the old entail as heirs male to John the father, and the devise gives no more nor otherwise than they take by the entail, and therefore it is void, the which is apparent by the comparison of the descents, for the estate tail devised by the will expires equis passibus with the estate tail in John the elder, and therefore if the fee in John the elder, out of which this devise takes effect, was a remainder, it would be void. But here, in this case, it is a reversion, and though such a bequest of a remainder would be ill, yet it will be good of a reversion, though it could never by any possibility take effect in possession. And this is the express difference in Comely's case, and the reason is because tenant entail holds of him in the reversion, and he of the chief lord. If a man makes a fofement in fee to the use of himself for life, remainder to his first son, and entail, remainder to himself and the heirs male of his body, remainder to himself and his heirs, he has but a reversion, and though the tail devised out of it can never take effect in possession, yet it is a good devise of such estate in reversion, for John the brother will hold of Thomas, and Thomas of the chief lord, and the lord shall avow upon Thomas modo et forma predicta, so that it creates a sentient tenancy, though it can never take effect in possession, and this is a sound diversity. But then, supposing that this fee in John the father had been a remainder, and so the devise is in the will void, yet the lessor of the plaintiff will have a good title, for the words of the will sufficiently explain the intent of the testator, and the limitation will be good. And in Baker v. Willis, an estate tail in a husband and wife, which was barred by a fine levied by the husband, was revived, so as to give her an estate tail descendable to her issue in tail. The case was, husband and wife were tenants in special tail by entireties, with remainder to the husband. The husband alone levied a fine with proclamations and conveyed to the Earl of Huntingdon in fee. The husband died leaving issue. The wife entered, and the Earl of Huntingdon, reciting that the said Elizabeth held the tenements in tail, remainder expectant to the right heirs of the Earl, ratified, assured, and confirmed to the said Elizabeth all her estate, right, title, and interest in the said tenements, habendum to the said Elizabeth and the heirs of the body of her and the said J. Beaumont engendered. It was agreed that the fine of the father was a complete bar to the right of the issue of the husband and wife under the original entail, and that the wife still continued absolute and complete tenant in tail. Hence arose the question, whether under the confirmation she had an estate tail descendable to her issue in tail, and by coke judgment ought to be given for the plaintiff. First I agreed that the fine with proclamations was an absolute bar and discharge of the estate tail against John Beaumont and the heirs of his body by the express words of the statute of 32nd Hen. 8th, and it is quasi-extinct against him by the fine, vid. Company Lib. 3, Fol. 51. Sir George Brown's case, and 5th Hen. 7, 30. Secondly, I agreed that when Elizabeth entered within the 5 years after the death of John Beaumont who levied the fine she is absolute tenant in tail, for the fine quote the said Elizabeth is absolutely avoided and she is in, as in her former estate, which is an absolute estate tail, and no tail after possibility of issue extinct, and if she be to sue any real action, she is to name herself tenant in tail, vid. D. 331 and 351. Thirdly, that notwithstanding the estate tail is barred by the fine, yet this confirmation being by indenture hath revived the estate tail, for although he in reversion by reason of the fine may enter and have the land, and the issue after the death of the wife is barred, to claim it, yet by this confirmation he in reversion hath excluded himself against his confirmation to claim it, for he may exclude himself of his estate, and as he may avoid so he may confirm, vid. Coke, Lib. 1, and Mayo's case, 11 Hen. 7, c. 28, n. b. 98a, where a tenant in ancient demesne levies a fine, and c. And although at the time of the confirmation he had nothing to confirm, and his words of confirmation will not add to the estate of the wife who had an estate tail, yet by the words habendum the tenement there is a new estate tail extracted out of the reversion, and settled in Elizabeth so as that confirmation is quasi perficiens et crescens, and, as the case in Littleton, theme tenant for life takes a husband, a confirmation to the husband and wife, habendum the land to them, increaseth the estate to the husband. Coke, Lib. 9, 139b. And whereas it was held that she had as great an estate before as she had by the confirmation, and therefore the confirmation was void, I held that although she had an estate tail yet she takes by the confirmation, for a deed shall never be void when by any intendment it may be allowed to be good and to have any operation, and she takes it for the benefit of the heirs of her and her husband's body, and although the heir be barred by the fine, yet he is restored to the estate tail by the confirmation, for as the fine was an estoppel to the heir to claim against the fine, so the indenture of confirmation is an estoppel to him in reversion, to say that he shall not hold it in tail, and there it is an estoppel against an estoppel which sets the matter at large as it is. Cokelet. 352b, 12h. 7, c. 4. And, although it was said by my brother Berkeley, that the Earl of Huntingdon hath but a possibility to have it after the death of Elizabeth, and that he hath it but as an occupant to have and enjoy it during the time that John Beaumont had issue of the said Elizabeth, I utterly denied that he hath but a possibility, for he hath it as in right of his reversion if his confirmation had not barred him, and that appeared by Austin's case in Plowden's Commentaries, and in 38 and 39 Illas. Hussey's case, where an estate is barred or discharged, or distinct as Sir George Brown's case, Coke Lib. 3, Fo. 50 terms it, where he in reversion shall have it as in point of reversion, and if he hath but a possibility, yet that may be well transferred by confirmation or release to him who hath the possession of the land as it is resolved. Coke, Lib. 4, Full. 64, Fullwood's case, and Lib. 10. Full. 48a, Lampett's case, and as it is holden. Coke, Lib. 1. Cut's case, that there is no condition, proviso or any other title but may by apt words be determined the one way or the other, so here, every party agreeing, the estate tale shall be revived, or at leastwise newly created, and the law shall adjudge it according to their intent, and therefore I was of opinion that judgment should be given for the plaintiff. But Jones and Brandton, C.J.J., deferred their arguments that day, hearing that the parties were about agreement, and afterwards by our means they compounded. And Sir John Beaumont agreed to pay £5,000, and the others agreed to assure the estate by fine or otherwise, and c. 8 sic materia predicta sopit fuit and no judgment given. But Jones told me that he was clear of opinion that the plaintiff had good title, and that the confirmation was good and created a good estate in Elizabeth descendable to her heirs. This case, though hitherto considered as an authority for the position that a base fee will merge in an estate tale, seems to determine nothing more than that, after the confirmation, the estate tale was revived because the reversioner had excluded himself by his deed of confirmation, from claiming the land against the issue after the death of the wife. It is now however decided that a base fee will not merge in an estate tale in remainder. Thus, in Doe v. Woodruff, decided by the House of Lords, an estate was limited to a man and his wife, and the heirs of their bodies, with remainder to the man in fee. The man died, and the wife after his death granted her interest to her son and heir, who thus acquired a base fee. The son became also tenant in tail in possession on his mother's decease, and it was contended, that by the union in his person of the base fee acquired under the conveyance from his mother, with the immediate reversion expectant on the failure of issue in tail under the settlement, a merger took place, but it was held, that the intermediate estate tail, which, being preserved by the statute to Donis, was still subsisting, prevented by its interposition any such merger from taking effect. Determinable fees, qualified fees, and conditional fees will merge in the fee simple, but they will not merge in a fee tail. If a tenant in tail of an equitable estate take a conveyance of the legal estate to himself and his heirs, the equitable estate tail will not be merged in the legal fee. Neither will it be merged if the legal fee descends to the equitable tenant in tail. But an equitable estate tail in remainder was barred by an equitable recovery by the person who had the whole legal fee, and upon the grounds that to create a merger of the equitable in the legal estate by their union, the interest in each must be the same.